Good evening, everybody. Thank you for tuning in. My name is Sheila Kololo. For those that are tuning in for the first time, I do give lessons on how to prepare for your board exams. So today we'll be doing your out and out session agreement, right? So a lot of people think drafting of contracts is difficult, but it's really about you having the understanding behind the contract that you're about to draft. So without wasting any time, what is a out and out session agreement, right? So a session, we definitely know that we are transferring something. So what's an out and out? An out and out is a type of session agreement where all rights and interest in a personal right, like the right to claim a debt or something, are fully and permanently transferred from one person to the other. So the original person who holds the right would be referred to as the cedent, and then the person that we are now transferring the right to would be then the cessionary. So that's what an out and out session agreement is essentially. So now let's make a scenario. I'm going to make a scenario and we'll follow through that scenario for the whole agreement, just so that we don't lose each other and it's more easier to understand using scenarios, right? Let me just make sure I am recording. Okay, yeah, it is recording. So suppose Sheila, I am a forensic consultant, right? And then I recently completed a project, let's say for the Department of Roads and Transport, right? And they owe me 100,000 for my forensic services that I rendered. And then now I don't want to wait 60 days or 90 days for my invoice to get settled. I need cash as in today. I will then go to Mary, who is like a private investor, and ask Mary if she can lend me, let's say, 85,000. And then I will give Mary the full right to collect the 100,000 from the Department of Roads and Transport, right? So I rendered services, they owe me, but because I need money urgently, I cannot wait for them to settle my invoice at the time they can. I then go to someone else, and then that person maybe gives me something, and then I'm like, okay, so instead of claiming from me, Mary, you are going to claim from the Department of Roads and Transport, right? And then Mary agrees, and then this is where now the session comes in. In simple terms, it's just us transferring a personal right which Sheila has from that personal right transferring from Sheila, who is the cedent, and Mary, the cessionary right. And since then it's an out and out, it's permanent. Once the agreement is signed between us, the parties, um, Mary will then officially become the legal creditor to the Department of Roads and Transport, right? So now let's follow through. Let's break down the actual agreement between myself and Mary clause by clause and talk about what each part really means. So the first part, we know this. There can never be a contract without the parties, right? So we obviously have the cedent, who will be Sheila, who is the original right holder, and then the cessionary, who is now Mary, who will be receiving the who will be getting the right. So this clause basically identify who is transferring the right, Sheila, and who is receiving it, which is Mary, right? In real life, obviously, we would include things like your ID numbers. If it's a company, it's a registration number and addresses. You always want to make sure that your contract is specific as to who is involved, right? Think about it like this. You don't want to later come back and say, but I didn't know which Mary you meant, or I didn't know which department you were referring to. So you always have to be precise. In your parties, in your exams, you would rather write too much than too little. Remember, if it's a company, you would also have to state that person is acting, let's say, the Mary is acting, let's say, by virtue of a resolution. So you'd obviously, if you state a natural person acting on behalf of a company, you have to say that person is acting by virtue of a resolution passed on. That's smaller than a sentence. It's just to say that person has the authority to be contracting on behalf of that juristic personality. But basically, in your parties, let's say it's a company as well, you'd obviously have the registration number of the company, the name of the company, the registration number, as well as the address. Same goes for the party's name, the party's ID number, their addresses, and therefore details as much as you can, just for precision. And then we move on to background. So you are obviously now stating why are we are we entering into this agreement? So you would look at something like, okay, let's say for the scenario that we're working on, right? The cedent is now Sheila, but obviously for the sake of the contract, we're going to refer to um Mary. Sheila will be the cedent and Mary will be the cessionary. Don't forget to also mention this here, right? Because you obviously have to put in bracket with your inverted commas. After naming Sheila, you would say cedent and then inverted comma close bracket, and then same goes on the part for Mary. You would obviously have to state it like that, just to show that okay, this person is the cedent, this person is the cessionary. Stationary. Say, is it a stationary? Okay, guys, whatever it is, but yeah, you get what I'm saying. Ne? So on the background, right? Back to the background. So let me give you something. You would maybe say like the cedent is the lawful owner of a claim in the amount of 100,000 against the Department of Roads and Transport for forensic consulting services rendered during July 2025. The cedent wishes to cede this claim to the cessionary, yeah. Why do we include this? Because it tells the story, it gives context, it confirms that Sheila is the rightful owner of the claim and that she is choosing to transfer it. So in your exam, naturally you should know your contract has parties. And then you should now, because you've got a scenario, they explained that Sheila wants to do one, two, three. You come now in your session, out and out session agreement. You explain why these parties are entering into this agreement. So you see, naturally, this builds a thought to say that, okay, I've got my parties. Now, why am I drafting this contract? Oh, it's the background. You see where you're getting at. Okay, cool. Now we've got our third clause, which is the price. We know, guys, we can never have a contract with, especially that has contract sounding in money. You always have to state why the amount involved in this. So you will then state that the purchase price payable to the cessionary, payable by the cessionary to the cedent for the claim ceded is 85,000, right? Right. Remember, I'm gonna get 85,000 from Mary, the private investor, and Mary's gonna give it to me within let's say 2 days of signing this agreement. Remember, I can't wait 60 days and 90 days. I need money. We're gonna state, okay, when will Mary give me this money? We state the time period, right? And then so let's pause here. So basically here, um, with the price, we are stating also the methods on which the money will be payable, right? Because we need to always have a condition for payment. Um when is Sheila gonna get the money, right? 2 days. How? By bank transfer or whatever. You really don't have to crack your head on this one, but um you just need to be precise, right? So, but you must always remember that with a thing like this, like let's say the context of Sheila, we know that Sheila is selling her 100,000 debt that someone else has, that she has against someone for 85,000. And Mary is now taking the risk that the department might not pay or might take longer to pay. But Sheila, in 2 days of the agreement, she wants her money, and she wants it by bank transfer. So, yeah, and then we go to your session. So this is the session clause itself. So now we are saying we are engineering the contract, right? So here you are stating basically what is being transferred, the parties are accepting, what is being confirmed, the cedent relinquishing any right and stating that there's no way that it can be reversed. And your clause in this instance will be like something like the cedent hereby cedes, assigns, and transfer to the cessionary all her right, title, and interest in it, and to claim. The cessionary accept the cession from the date of this agreement. The claims become the exclusive property of the cessionary. The cedent renounces any right to claim. No revisionary right is retained. This clause is basically saying, this is what I'm giving this person, right? This person is also accepting it, right? We confirm that this has been done, right? And Sheila will no longer have a claim, and there is no reversibility of this, right? It's done, it's done. There's no way that you can come back and want to give me stories. So always know, or maybe just have like, you see these, it's 1, 2, 3, 4, 5 points. Always say, okay, fine. This is what is being ceded. The decisionary accepts it. All rights have been, parties confirm that the rights are ceded. The cedent does not have any right to claim anymore. And then it's not reversal, So you can just give yourself at least 5 things that you have to mention in your paragraph so that you cover the entire scope of this clause, because this clause is basically your engine for your contract. It is the one clause that you cannot miss. So always make sure that you can take yourself to say that, okay, this is being ceded, the decisionary accepts, we are confirming. Sheila does not have the right anymore. It cannot be reversed. And then, yeah, that is it. And then we've got the next one. It's the delivery of documents evidencing book dates, right? So you must always obviously deliver or make available all documents related to the ceded claim upon request, right? So we are obviously, the person would need proof that I have an invoice has been submitted, finance accepted the invoice. Unfortunately, the department's policies that they pay within 60 or 90 days, but everything is underway, you right? Because you also cannot misrepresent and say, give me 85,000, you can claim 100,000, only to find out there's not even money with the department. The department rejected my claim. So you obviously have to make sure that you deliver the documents evidencing the date. And then in something like in a clause like this, you'd obviously state something that the cedent shall, on request, deliver to the cessionary all documents relating to the ceded claim, including invoices, contract, and security, because we know Mary needs proof of the claim to enforce it, right? And this clause is just to make sure that I assist by handing over all supporting documents that serves as proof of my claim that I had against the department. And then we go to warranties by the cedent, right? So here we are just saying, okay, the cedent warrants that no agreement prevents transferability, no knowledge of counterclaim, no prior warranties of same claim, will not receive the same claims, all debts are valid and enforceable. We are just now tightening the belt to say that yes, so the claim exists. There's no counterclaim against us. There's no other party. Let's say I rent to another private investor and say, give me this money, and then he gave me, and then I promised him the same 100,000. This is just to give the cessionary that sense of security to say that there is nothing really stopping the cession. The claim is valid and enforceable because I still have the money with the department. The department is still owing me. Um, the claim was never ceded. I did not go to another private investor and say, okay, please give me 70,000. I've got 100,000, things like that. I have not waived my claim with the department, and I will not recede the claim. So this is just basically me giving the department, I mean, Mary, that sense of security that this is it. Like there is no mshiga shiga, there is nothing. going on, you can claim. I guarantee you that this claim is enforceable. It is valid. The department is aware that they owe me and things like that. No one, I know I did not run to someone else and try to claim from them and also promise them the same 100,000, which is also that I gave them papers to this effect that they can claim from the department. You know how people can be very good at scamming. Yeah, just as a safety net against that. And then we've got revisionary right? If it appears that claims were previously ceded, this would then be coming to play. So it provides that if any claims were previously ceded, the cedent cedes any revisionary right, and he may have in respect of such earlier rescission. So um, this is basically saying whatever was ceded previously um, does not have effect, right? This is ours, right? This is our session between Mary and I and no one else. This is ours, right? Um, yeah, that's just basically your revisionary right. And then clause number eight deals with notice to debtors as just basically authorizing the sessionary to give notice to the debtors of the session. So now what this says, it says that Mary shall be entitled to notify the Department of Roads and Transport of the session and request the direct payment. So now going forward, Mary has the full right to engage with the department in terms of seeking payment of the debt. And then we've got information regarding the the what's this? The book dates. So it's just basically still similar to the earlier one. More like the student shall on request provide a list of all debtors, make records available for inspection, and supply all necessary information to assist in the recovery of the date. I have to obviously, when needed, if more information will become needed, I will facilitate the assistant. I will avail myself. I will deliver a list of all debtors. I will make the books available for inspection. I will provide all necessary information to help Mary enforce her claim. That's basically what I'm saying in that. And then we've got costs of enforcing against the debtor. So here we are saying that the cedent is not liable for costs incurred for the cessionary in enforcing the claim. So let's say the department now is taking long. I will not be liable for costs that Mary would incur in trying to make the department pay, you know. So it's just a clause that is talking about that. And then we've got further and common terms. These are your boilerplate clauses, right? So boilerplate clauses, remember, it's clauses that are usually there in a contract. For instance, your whole agreement clause. So this clause basically means that everything the parties have agreed to is written in the contract. Nothing more, nothing less. Why is it important? It protects both parties from one side later saying, but you promised me one, two, three during our phone call, or you said something different in an emails, right? So without this clause, someone could try to rely, let's say, on an oral promise and say, but Sheila, you said, or whatever. So this clause basically shuts that down to say that everything that is written in this agreement is it like there's not more that isn't less, right? And you can word it in something like this agreement constitutes the entire agreement between the parties and supersedes all prior discussion, negotiations, or agreement. It's basically you saying everything that's in this agreement is it. You don't always have to give it in legal language or contract language in an exam. Just state it in a way that we know that you understand what a whole agreement is. And then we've got the jurisdiction clause. We know this at this point. We are saying, where are we gonna take the matter? Right? If you want to sue me, where should we go? Right? Which court will handle any legal dispute between Sheila and Mary? Without this, basically, you can find one party trying to sue you far away or in an expensive court, right? So this clause basically tries to simplify things and save legal cost, right? You can also limit it to say that before you go to high court, let's start at match court, considering that our contract obviously falls within its jurisdiction. So it's things like that. Then you state like the parties hereby consent to the jurisdiction of the magistrate court of Johannesburg. If I cite courts wrong, guys, forgive me. Now I'm a forensic auditor and not an everyday attorney, so forgive me for that. For all matters arising from this agreement, right? So we are basically saying, um, if we ever have to litigate, please, we are going to the match court in Johannesburg. That's it. Don't take me to Pretoria. I said Johannesburg. We agreed Johannesburg. So that's it. And then we've got our variation. So we are saying in this one, there's no variation, amendment, or addition to this agreement unless we reduce it to writing and we sign as both parties, right? We do not permit any changes unless we write them down and we sign. Both Sheila and Mir ought to do this, right? This is to avoid informal and informal amendments, right? Let's say then I come back later, I'm like, you can pay me 70 instead of 85, and it's not written down. It doesn't count, right? And then we have an agreement to say that, okay, you're not gonna claim 100,000, Mary. I call Miriam like, you're not gonna claim 100,000. You can claim 95. I will take the 5,000 from the department, right? And then our agreement says something else. Obviously, it's gonna be conflicting. Hence, we now have to make sure that we've got a variation clause that says, unless it is in writing and signed by both me and you, it does not have any effect. Just to make sure that everything that we agreed to is written down. If it's not written down, then it does not have any effect because we don't want to now have to end up in the match court litigating to say that, but no, Sheila, you said now I can claim 70,000. Oh, like I said, Mary, give me 70,000 and claim 95 from the department. There is 5,000, I will claim, to avoid things like that. And then address for notices, you know this by now. We are basically saying this is the formal address where I agree to receive legal document notices or any communication. Um, this is just basically to also ensure that if any of us deliver something, right, or there's a breach, if I don't know your address, and I deliver somewhere, you can always say you didn't receive it. But if you do have a address in the agreement and we both agree that should there need to be any exchange of documents or whatever, this is where you're delivering it. You can never now come back and say, but no, you didn't receive it. Don't. This is your legal address. If the sheriff or someone leaves a document at this address, we are expecting for it. You ought to be aware because that is your address. And then we've got governing law. Governing law, obviously, we know this. It's in South Africa. We're going to say this. Um, this agreement shall be governed by and interpreted in accordance to the laws of the Republic of South Africa. Just basically saying we are going to use it in terms of our South African. We are interpreting it in terms of in line with South African laws. There's really nothing deep to it. So yeah, guys, that's it for the session out and out decision agreement. It is very straightforward. At most, what you need to make sure that you list down and try to remember is the list of the clauses, Like I think the first five you should be able to naturally remember. And then the others, obviously, considering the bulk of contracts that you have to try and remember for the exam, it might not be easy to remember that well. So for that, learn maybe the headings, Learn that, okay, maybe a session and session at most has 10 clauses and list those clauses because the most important thing for you to understand is what does the clause talk about. Once you understand what the clause talks about and you know the heading, it's very easy for you to know what's what because you don't have to now try and cram what's in the um what's this what's in the guide. And by the way, these headings are from the guide. So you don't have to force yourself to remember the word for word because you understand what the clause is addressing. So you just need to remember that, okay, an art and art session has about 10 clauses, and then I can throw in maybe one or two boilerplate clauses to show the examiner that I know that we still need a whole agreement clause or a jurisdiction clause or just any two. You don't really need to remember all five. It's just any two to show them that you know how to draft a proper agreement. And then just an exam hint, how you would spot an out and out session question. So let's say you're reading a problem scenario, right? And you're not sure. You can see the date, but you're not sure what it is. Look for triggers like this. There's a transfer of a right to claim money, right? For example, they will state that Sheila agrees to transfer her right to claim 50,000 from the department to Mary. So you see already Sheila has a right. There's a department, and then there's Mary, who's now getting that, who now Sheila is transferring her right to claim from the department to Mary. So that tells you that, oh, okay, there's a right to claim that is being transferred. Someone obviously is giving away their right to claim something from one party and giving it to someone. So, okay, this is a cession. And then you see that now the transfer of this personal right is permanent, right? So if it's permanent, there's no security arrangement or reversion clause, then you say, that, oh, okay, it's an out and out. Perfect, right? It's not for sake of security. It's permanent. Once concluded, we are out. And then the other one is there is a third party data involved, but is not party to this agreement. Then you saw that, okay, the department owes Sheila, but he's not party to the agreement. The agreement is between Sheila and Mary. Then you see that, oh, okay, this is a out and out. And then you see that either there's a sale of book or book date or invoices or something, but something is being transferred, right? Or something is being transferred to someone, right? So that's it. So then that's how that's in like that's the clues that you will use to spot your session and session. And automatically, once you start, you should be able to remember that, okay, I've got a session agreement. A session agreement always has the parties. Okay, then you're done describing your parties. You ask yourself, okay, why am I drafting the session agreement? Oh, hint, that means I also have to state um the background to the session agreement. Why is Sheila transferring her right? And then, okay, yes, but what's the value? What are we being what's the price, the purchase price, the methods that then this money will then be given to Sheila. And then the session, all the ticks that, okay, we are sitting this, Mary is accepting, we are confirming, Sheila does not have the rights anymore, and there is no reversion of rights. And then, okay, now Sheila needs to give, obviously, to Mary all the books evidencing the the debt, right? Because Mary needs to be sure that yes, there is a debt. She needs proof, the invoices, whatever it is, the contracts and all that, that confirms that the debt exists. And then once you're done with that, you know that okay, because obviously Sheila needs to give Mary that sense of security that yes, this debt exists. No one else has a claim against it. It's enforceable. Mary can take all these documents and go to the department and actually be able to get her money, you know. So then you have your warranties and then the revisionary to say that, okay, um, didn't seat any revisionary right. If there was a revisionary right, it's also ceded to um Mary. Now, and Mary has the right now to give notice to the debtors of the decision to say that this is the decision. I am now the legal debt holder. I'm your new creditor. You have to make payment directly to me and then give information regarding the books. And then you also state that myself as Sheila, I will not be held liable when you're trying to recoup your money from the department. If the department gives you runaround, if you have to litigate in order for you guys to conclude the debt, leave me out of it. And then your last two or three clauses, depending on how much you remember, you can put your 3 or 4 boilerplate clauses. Sometimes they do put a comment in the exam that you do not need to write your boilerplate clauses. Then if they say that you obviously do not need your number 11, you can just end at number 10. You sign off. Remember, a contract needs to be signed off. So be prudent enough to sign it off. I'm not sure if they're strict, if they do really want to give marks for that, but you'd rather be safe than sorry. But yeah, other than that, guys, that's it from me. That's your session and session agreement. I will be, a session, an out and out session agreement. I don't know what I was saying, but yeah, guys, I ramble and mumble at times. Forgive me. I'm just a hardworking individual and dedicating time and love so that you guys can understand this a lot better and easier. And yeah, please share the video. And if you find it helpful, I also do have notes for students at 254 paper 3. And then because this will be posted on YouTube, please share it with your friends that are writing board exams. I mean, contract is not that difficult. It's just for you to understand the clause, what needs to be in the clause. As long as you know your clauses, how learn the thing like you're learning a spelling test, like out and out session agreement, they like parties, background, price, the session, delivery of the books, warranty, things like that. Then you actually see that, because I know what warranty deals with, I just need to remember that there's a warranty. What goes on in a warranty, I understand very well. I'll see that in the exam. But nonetheless, guys, let me love you and leave you. I hope this video is not more than 30 minutes. If it is, Askis, I usually say this, and then when I stopped the video, I noticed that, oh, okay, but I've been talking for like, oh God, 15 minutes. But Askis, guys, I'm doing this for you. Bye.